Contractual agreement. Part 1. Offer and invitation to treat. Contractual agreement has traditionally been analyzed in terms of offer and acceptance. One party, the offerer, makes an offer which, once accepted by another party, the offeree, creates a binding contract. In order to amount to an offer, it must be shown that the offerer had the intention to be bound. This was established in Harvey v. Facey, where it was held that the reply, lowest cash price for bumper hall pen, £900, was not an offer as they had not directly answered the question of whether they were willing to sell. Conversely, in Carlisle v. Carbolic Smoke Ball Company, the promise to pay £100 to persons who used the smoke balls and caught flu was an offer as they had stated they had deposited £1,000 in the bank for the purpose of paying claims. This demonstrated their intention that the promise was indeed an offer. An offer needs to be distinguished from an invitation to treat. Whereas an offer will lead to a binding contract on acceptance, an invitation to treat can't be accepted, it is merely an invitation for offers. Goods on display in shops are generally not offers but an invitation to treat. The customer makes an offer to purchase the goods. The trader will decide whether to accept the offer. This was established in Pharmaceutical Society of Great Britain v. Boots, where there was a requirement that the products were sold in the presence of a pharmacist. An example of this can be seen in Fisher v. Bell, where the defendant could not be liable for offering a flick knife for sale. The knife was on display in his shop window, so was not an offer but merely an invitation to treat. The case of Partridge v. Crittenden established that advertisements are generally an invitation to treat rather than an offer. The defendant placed an advert in a newspaper offering wild bramble finches for sale. These birds were a protected species and it was an offense to offer them for sale. The defendant was not liable since the advertisement was an invitation to treat. However, in some instances an advert can amount to an offer. In Carlisle v. Carbolic Smoke Ball Company, it was established that, if the advert was specific enough, limited in numbers and demonstrated an intention, then a newspaper advert could amount to an offer. By stating they placed £1,000 in the bank, they had limited the number of claims to the first 10 who used the smoke ball and caught flu. Spencer v. Harding established the position with regards to contracts by tender. The request for tenders represents an invitation to treat, and each tender submitted amounts to an offer unless the request specifies that it will accept the lowest or highest tender or specifies any other condition. If the request contains such a condition, this will amount to an offer of a unilateral contract where acceptance takes place on performance of the condition. Where an auction takes place with reserve, each bid is an offer which is then accepted by the auctioneer. Where the auction takes place without reserve, the auctioneer makes a unilateral offer which is accepted by the placing of the highest bid. This was seen in Heathcote Ball v. Barry, where the defendant auctioned without reserve 2 engine analyzers worth £14,000 each. The claimant was the only bidder and put in a bid of £200 on each machine. The defendant refused to sell them to him and was required to pay £27,600 in damages for his refusal to sell them at the contracted price. The position of contracts made by machine was considered in Thornton v. Shoe Lane Parking. The ticket machine was held to amount to an offer and putting in the money was the acceptance. The Court of Appeal considered that by putting in the money they had reached the point of no return. In summary, an offer needs to be distinguished from an invitation to treat. An offer must have an intention to form a binding contract. An invitation to treat is part of negotiations but does not directly lead to a binding contract. Goods on display in shops and advertisements are generally not offers but can be in some circumstances. Auctions depend on whether it is with or without reserve. Tenders are generally offers unless a condition is specified. Where a contract is made with a machine, the question is whether they have reached the point of no return. This video is part of a series of videos on contract law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.